Hello, everyone, and welcome to One Civil Law, where, as always, we learn through the misfortunes of others. I am your host on Civil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court. And as always, I hope you're having a great day. For today's story, we turn our attention once again to the great state of New Mexico, the state of enchantment, in which Hannah Gutierrez-Reed, as I'm sure you will recall, the armorer from the Rust movie set, was convicted and sentenced to 18 months of imprisonment for the involuntary manslaughter. Hannah Gutierrez-Reed, at least according to the evidence presented at trial, brought the rounds onto the set herself, and then, of course, loaded the rounds into the gun, and then, handed the gun off, and then the bullets fired. So that sounds like a lot of problems to me. Now, she would like to have her trial set aside, she says, for discovery violations, and for other things. Now, of course, what is true for Hannah is not necessarily true for Alec Baldwin, and vice versa. So, of course, we all know the trial against Alec Baldwin was dismissed because of violations as it relates to him. But whether or not there are any violations as it relates to her is a whole other set of problems, because they are a separate trial with different lawyers and possibly different disclosures. So, of course, each case has to be analyzed unto itself. So we're going to try to do that, and we're going to analyze this document and see what it has to say on the issue. Great. The defendant, by and through her counsel, moves this course for a new trial or for dismissal based on the discovery violations. Yeah. All right. In a hearing on July the 12th of 2024, in Baldwin's case, Miss Morrissey took the stand, calling herself as a witness, and lied to the court several times. Nice. You sent me a Discord message? I'll take a look at it right now because I'm not getting too busy. Maybe. I will consider your request. Thank you for your super chat or for your Discord message. All right. Corporal Hancock testified that Miss Morrissey was in on the decision to file the rounds into a separate file. On direct examination, however, Miss Morrissey stated she never knew it would have a separate file number, which isn't necessarily a lie, but okay. Miss Morrissey alleged in response, because it's not necessarily a lie. It doesn't necessarily require either one of them to be lying. Lying, of course, requires, in a technical sense, for you to know that you're telling a falsehood. And she might think that she could very well, it could be the case that she's like, I want it in a different file, but not know that would mean it would have a different file number. I mean, that's possible because she's not a police officer. She might not know exactly what that would mean. So she may not necessarily be lying. It could be a lie, but it's not necessarily a lie. Anyways, pressing on. Miss Morrissey alleged in response to cross-examination that her co-counsel had resigned that day because it wasn't a public hearing on Brady violations. That was false. Well, that might have been her perception of it, which again doesn't necessarily mean it's a lie. Or it might have been one of the reasons. I don't know. An immediate interview that same, and even if it is a lie, I'm not sure how it necessarily gets to her, but we'll see. In an immediate interview that same day, her co-counsel explained that she resigned because of ethical duties, and that she had argued the case should be dismissed by the state because of late disclosure, and that she was overruled, obviously by Miss Morrissey. Okay. Miss Morrissey instead decided to plow ahead in her continued win-at-all-costs attitude in the Rust case. Second, Miss Morrissey represented in response to questioning that she had asked her prior paralegal to resign. This was factually untrue. The factual decided to tender his resignation unilaterally after sending several emails to the DEA's office about working conditions and the conduct of Miss Morrissey that they had led a unilateral decision to resign. The parallel emailed this undersigned counsel and exercised an affidavit. Again, it could be a different perception thing. So, whatever. Third Miss Morrissey, because again, it's just like, the point I'm trying to make here is a bit of a broader point. It's like, just because two different witnesses are telling a different story doesn't necessarily mean that they're either one of them lying. Lying requires technically for it to be knowing. That you have to know that you're telling a falsehood. Something can be false and not a lie. If you don't know it, then it's not a lie. And people have different memories. And people have different vantage points. and people have different conversations. So lots of people can tell stories, sometimes inconsistently. It doesn't necessarily mean any of them are necessarily lying. It doesn't, and it may be the case they all can't be true at the same time, but it doesn't necessarily mean that they're a lie. So just saying. All right. Third, Morrissey represented that undersigned counsel did not want the rounds and believed that they inculpated Miss Reed. This is absolute falsehood. Okay, so this would be a little bit more interesting because she says she made the disclosure to Hannah's counsel. Now Hannah's counsel's like, no, you didn't. So, okay. Some background is necessarily on point. The state has been aware and had access to Teskey for years. Seth Kenney called Teskey during a November 1, 2021 interview with then Detective Alexandra Hancock, after which Teskey sent a picture of sampling ammunition, and sampling had Brown's primers and didn't match the live rounds on set, which had nickel primers. There was no further follow-up of the state, even though undersigned counsel texted Detective Hancock asking her to contact Teskey. Detective Hancock also misrepresented at the hearing, said she called Teskey multiple times with no response. Hancock in text responses told undersigned counsel she had already talked with Teskey. Yes, I've been present for most of the phone calls and have spoken to him, and also saying I'm aware, I've seen them and spoken to Troy. Hancock never again tried to contact him despite the testimony in court. Well, this looks like this is heading into the territory of a hearing now, because Miss Morrissey's credibility is a little bit thin at the moment. And so I would imagine now we're looking at a potential hearing where we might have witnesses about who said what to whom exactly with respect to discovery and stuff. So it might get into the weeds. So yeah, this is heading into we might need a territory fuel. Then on November 2nd, 2023, a pre-trial interview of Teskey, the rounds again were discussed, this time with a special prosecutor. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenney had taken to the 1883 set. Teskey agreed he'd preserve it and provide it to Morrissey, indicated he should, and that they would work with law enforcement to collect it. Thereafter, Teskey was afraid to do anything with the rounds except to preserve them for law enforcement, which he did. Morrissey never followed up. The undersigned sent an email to Morrissey on January 8, 2024, asking if the state was going to retrieve the rounds and test them. Counsel stated in the email that testing was important to compare the powder of the Teskey rounds to the powder of the live rounds found on set. This had to be done through the FBI, through the state, as the FBI had done the original testing and analyzed the powder. I'm not sure if it had to be, but, it could be. Undersigned counsel had repeatedly told the state it needed to test the rounds and make the comparison. That same day, however, for the first time since November 2nd, Ms. Morrissey emailed back to say she did not plan to retrieve or test them because she found them visually dissimilar and not relevant. And if she said that in an email, then, that's obviously something that is traceable and lends credibility. So I see ourselves heading towards a hearing at this rate. Astonishingly, Ms. Morrissey told the court that she had never seen the rounds until July 12th during the evidentiary hearing. It was clear in the hearing that 3 of the rounds were visually like the Rust set rounds, which contradicted Ms. Morrissey's statements in her January 8th email to undersign, and Ms. Morrissey's in-court statements from July 11th that the rounds were not visually similar. Further misconduct by the state unearthed in that hearing was that CST Papel had directed to take the Teskey rounds into a separate case file with separate numbers, not Rust, and create a report that would also be filed in a separate case so that it would not be disclosed to offense. Well, I don't know if that was their intent, but that was the result, which when it comes to the first elements of Brady doesn't matter, because intent is not an element of the first elements of Brady. They have to disclose it no matter what their intent is. That's their obligation. Corporal Hancock testified that Morrissey was present to the meeting and the decision placed the rounds in a separate file. In other words, Special Prosecutor Morrissey was in on the decision to hide the rounds, well, that's colorization, but okay, and report on them in another file. Moreover, CST Papel and Morrissey misled the jury in testimony on July 11, 2024, indicating the Teskey rounds were visually dissimilar to the Rust rounds and therefore immaterial. This was proven false when the court opened the box and inspected them. Yeah, so Miss Morrissey's credibility is running a little thin right now, given everything that just happened. The judge is probably pretty pissed. And so, I'm sensing we're on our way to a hearing, because now we have some pretty important factual disputes about who said what to whom and when, with respect to these disclosures that may or may not have been made to the defense and may or may not have been hidden from the defense. Because Miss Morrissey's all over here like, I told the lawyers all about it, and then just like, we don't want it. And the lawyers are like, no, you didn't tell us that. In fact, quite to the contrary, we kept asking for it and you just told us no. So not only not that, but kind of the exact opposite of that in a lot of ways. So yeah, the same judge tried both cases. So yeah, she's going to be a little bit pissed. Far from distancing from the Teskey round, defense counsel recognized their potential exculpatory value had the state tested them. However, by the time Miss Morrissey indicated that she did not plan to retrieve them on January 8, it was too late to utilize the rounds and impossible without FBI comparison on the powders. Again, I'm not sure if that's necessarily speaking impossible, but it might make it more difficult. The court also made it clear in one of the motion hearings around that time there would be no continuance of the February 28th trial date with Morrissey. Regardless, without the state testing the rounds, counsel for defense was unable to utilize the powder comparison. Teskey then turned the rounds over to the sheriff's office, and defense hoped the sheriff's office would finally test and analyze those rounds, in which Ms. Gutierrez pursued her appeal. Instead, the state placed them in a separate case file and attempted to hide them. We may not be done with Miss Morrissey yet. Yeah. Erlinda Johnson recognized the importance of this round, as she stated in the interview, as soon as she saw the 3 silver primer Starline Bryce rounds on January 12th, when the court took the rounds out of the evidence box. Ms. Johnson indicated the theory of sabotage as a possible defense theory, and defense assertions that Ms. Gutierrez-Reed was a wonderful armorer. This goes to the foreseeability element as well, and could have been more exculpatory. So the defense is like, well, we think it might have been exculpatory in our case. Which, I'm somewhat more inclined to believe them because, whatever. Yeah. $4.99 from the Content Lasagna says, thanks for having an open mind. Always. Unfortunately, I won't be able to come through on my significant offer. Too rich for my blood. I'm broke. So you do not want any more. You do not want any more of me, of pics of me smashing lasagna with my feet. So I will not be doing your OnlyFans request of me stepping barefoot on lasagna and taking photos for your pleasure. This is very disappointing to us both. I was looking forward to the income and the lasagna. Thank you for your super chat. The import is that Miss Morrissey and CST Papel made misrepresentations to the court and jury regarding the Teskey rounds and the circumstances surrounding their late disclosure. These misrepresentations highlight the continued discovery abuses and fraud perpetrated and attempted to be perpetrated on counsel for the defense and by this court by the state. Counsel for Ms. Gutierrez-Reed knew that Teskey had some rounds from the same batch and is not making that failure of disclosure the sole basis for this motion, except to the extent that they show ongoing misconduct of the state and failures found by the court, although counsel for Ms. Gutierrez-Reed was also never provided with a copy of the police report or lapel video concerning these collected rounds. These additional acts by the special prosecutor should inform the egregious Brady violations regarding the report and Giglio violations, which is Giglio is just an extension case. Okay, Brady by its own terms only applies to the prosecutor. Giglio says, also the police. So that's what Giglio is, right? It's an extension case. So it's like anything in the prosecution's protection or the police's possession. So anything in the government's possession, more broadly speaking. So that's what those cases are talking about. Great. Okay. This court stated on July 12th, the integrity of the judicial system demanded the court dismiss the Baldwin's case with prejudice. How can it be indifferent with Miss Gutierrez-Reed case, with his proven litany of discovery abuse? Well, we're going to have a hearing, I think. And it may very well result in it being vacated at this point. I can already see it happening in front of my eyes, by the way. I could already see it happening. Like, it's not going to go well for the state, because why would it? Because their credibility is already super thin. They're going to have their hearing with their witnesses, and they're going to get to the end and be like, well, you know, we can fix this because we can simply vacate and set for a new trial, because now we'll have more time for discovery and we can give more discovery. And the defense is going to be like, no. And I think the judge will be more inclined to be like, this is going to go away because as a sanction, basically you've effed around and found out in the interest of justice and all the rest of it. So good times. All right, so we can read a little bit more of this, I think. At a stunning evidentiary hearing on Friday, July 12th in the Baldwin trial, the court found the state had committed an egregious discovery violation by suppressing material evidence regarding rounds that Teskey had turned over to Santa Fe, which the prosecution knew about and also had a direct hand in their filing, which then made it a Brady issue because the prosecutor was there. See, it arguably wasn't a Brady issue in the first instance because it's a different police office of a different state, which this prosecutorial office didn't control, right? So it may not be a Brady issue, and it may not be a Giglio issue. You know what made it a Brady issue? The prosecutor apparently was there themselves, helping the police to determine how to file the thing, which means that now the prosecutor is very aware it exists. So now it's a Brady violation. Great. That's just fantastic for the government there. That's just fantastic there. This court entered the extreme remedy of dismissal with prejudice, finding the special prosecutor and sheriff's office suppressed the evidence of the rounds. The evidence was favorable to Baldwin's impeachment. The evidence was material in the late disclosure impacted fundamental fairness. The state's conduct was highly culpable in failing to provide this discovery, which arguably those elements would be, the conduct would be equally true. Materiality, all these elements are probably pretty much the same, right? So, like, where would they differ, right, from Hannah, right? So, where would these elements differ? Okay, the special prosecutor and sheriff's office suppressed the evidence around. Would that differ with respect to Hannah? No. The evidence was favorable to Baldwin as impeachment evidence and potentially exculpatory. At least as to impeachment evidence, no. Impeachment evidence is any evidence that would contradict someone, and it already has contradicted someone, as the judge has noted. So at least as far as impeachment evidence, no, there is no difference. The evidence was material, and that late disclosure impacted fundamental fairness. Sounds like the same. The state's conduct was highly culpable. How could it be any less culpable with respect to Hannah? That doesn't make sense. The state's willfulness was so close to bad faith as to show signs of scorching. I'm not 100% sure what that means, signs of scorching. It sounds cool, but I don't know if that's like a legal turn of phrase or something, or where that's coming from. It's like, I'm not sure what signs of scorching is. I guess it's just like so hot it like touched the stove. So scorches? I don't know. This was highly prejudicial to Baldwin. And his preparation of trial. The sanctioned dismissal was the only appropriate remedy. Despite the state's repeated disclosures that it complied with all discovery, which also would be the same with respect to Hannah, they withheld the critical evidence, and dismissal with prejudice was necessary to preserve the integrity. Yeah, most, if not all, of these factors are going to be the same for Hannah. Right? So most, if not all, these factors are going to be the exact same. So it is not looking super duper promising. You know what I did that was wrong? You know what my mistake was? I just realized what my mistake is. And now that I realized what the mistake was, I feel really dumb. Uncivil did a dumb. Here was what Uncivil did. Okay. uncivil, despite watching the prosecutor literally get on the stand, despite the judge like pointing out how they withheld the evidence, and they kept away and hold the file numbers and everything else, and all the other problems that happened. Somehow, some way, when the prosecutor was on the stand and said, "Oh, I told the defense lawyer about it," and they chose to reject it, I took it at face value. That was my mistake. When the prosecutor got on the stand, it's like, "Oh, I told the defense lawyer about it and they just didn't want it." I just went, "Oh, okay." See, my mistake was believing her. Because, I was like, surely she wouldn't lie to me. But I think the defense is pointing out that I've been a bit of a fool here. Lame. I don't know. I have so much faith in my profession, and I'm just like trying to give her every benefit of the doubt, right? It's just like I'm trying to give her every benefit of the doubt. It was all just a mistake. Not that necessarily makes it legally okay, but it's all just a mistake. It's just a comedy of errors. It wasn't the prosecutor. The prosecutor just made a mistake, and it led to this weird place, and we are where we are. But the prosecutor's a good prosecutor, and will do their job honorably and rightly, and surely would not mislead the tribunal, because they're an officer of the court and they wouldn't mislead the tribunal, don't you know? Yeah. I'm coming to the realization there may be no Santa Claus over here. Yeah. This is, of course, the same special prosecutor in Same's office that handled the same case. Yeah, so most, if not all, those elements would break the same way. If I really put on my thinking hat, I might be able to make one or two of or three of them break differently. But why try? Like, if I really put on my thinking hat, I might be able to try to make them break differently. But why try? And even if I could, I'm not sure it would really matter enough in the end, because it's a balancing analysis. And even if I could like shave on the margins, it's like, what am I even doing? Yet after this trial concluded, the state continued its pattern of discovery misconduct, disclosing a completely new interview of Seth Kenney and a third expert report of the state. You're doing discovery after the conviction? On April 8th of 2024, a full month after the trial had ended, Miss Morrissey called counsel and disclosed an entirely new interview and statement that contained numerous points that could have been used in cross. Also, the state withheld bombshell exculpatory evidence that had a constitutional obligation to disclose and would have resulted in a fundamentally different trial and likely a different outcome. As the court is aware from ongoing proceedings in that case and Baldwin's case, despite it having in its possession the report from its own experts stating the firearm used on the set of Rust contained unexplained tool marks on critical surfaces of the trigger and sphere, which were likely not the result of damage incurred by the FBI's impact testing, do not have appeared to be original marks or use or abuse marks based on their irregular orientation. The state buried this information and never disclosed it. But not only that, the state then called an expert at trial and sat idly by as he perjured himself. Again, not necessarily perjury with respect to the expert witness, and I can't believe I'm still giving the state of the benefit of the doubt. Hold me. But even if that expert was testifying truthfully within their opinion, because I don't know what they testified to, and maybe their opinion is different than the FBI's opinion, which it could be, I don't know. But even if it is different, they would have every right to bring up this contradictory evidence and be like, okay, what do you think, expert, about this other report? You can challenge the expert based on other experts' opinions. It happens all the time. Usually it doesn't change their opinion, but you have the right to bring it up and show that other experts disagree with them at a bare minimum. So, all right. In doing so, the state suppressed exculpatory material, suppressed testifying witness written statements. Oh, it's the witness's own statement too? Oh. Oh, okay. It's the same witness. Oh. Well, that makes it worse. So, again, it's not necessarily perjury because the witness might have changed their mind or whatever, but now we're not talking about confronting them with a different expert. Now we're talking about confronting them with their own written opinion and be like, now we're impeaching them. And like, didn't you write this? And the expert can say, yes, I did, but here's what I think now and blah, 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 or whatever. But again, it's like you have the right to do it. And it's a written report from the expert. It's disclosable, man. This conduct is beneath what the court should expect from a duly appointed officer of the state. These late disclosures having occurred after the outcome of trial, there's a reasonable probability the outcome of the trial may have been different had the state complied. All right. All right, we're back. Great. Let's move on. In the Seth Kenney interview conducted well prior to the trial of Gutierrez-Reed, there's no date connected with the interview, but occurred before trial. Mr. Kenney makes the following material statements for counsel for Reed that would have been used in cross. $5 from Gutierrez-Reed. Scorching was the rebuke judge gave Carey's conduct. How close she tried to get to the line of impropriety. She was scorched by the fires of the flame, like Icarus flying too close to the sun, that kind of thing. Okay, I mean, that makes sense. All right, so here are the statements. So now they're saying, here's how it's material. Here's how I would have used it in cross. There is a standard that the prop master is the boss, and if something goes missing or stolen, she must report it. She is managing things, which allows the armorer to focus on guns, and Sarah is everything else. Hannah grew up on a set of movies and has a lot of immersion in the industry. She has more experience with westerns than Seth did up until 1883. Says prop masters who handle guns won't call it an armorer to test bullets. Mentions the sheriff confuses replica guns with real guns. Well, a replica gun is real, but maybe you mean something else. Sarah told Hannah was doing great with the guns and the director was happy. Seth heard nothing but good things about Hannah's skill. All the stuff that came out about safety he hadn't heard. He felt like people were piling on after the fact. Well, this sounds like useful information. He mentions the anonymous hotline. If there's something going on, why no one called the hotline? Alex Hancock has been cool, but I busted her chops during the search warrant. Says he got 325 rounds from Theo Reed. Says sabotage could be anyone on the set. It's a boys' club. Alec Baldwin trusts AD because he's a man. If she says she got pushed around, no one would disagree. She's got the experience. If she ever came up with that kind of defense, I think, well, you're finally going to be real about this thing. If the camera crew didn't feel safe, well, call the hotline. These are apparently statements in his report that she could have questioned about, but she didn't have access to. So we're getting the idea there. There's some things there. Several of these statements are new and different and would have been critical to cross-examination of Kenney, including to show Miss Gutierrez-Reed's experience. The allegations of being unsafe were not something Kenney had ever heard, that props and armorers needed more support, that if camera crew or others didn't feel safe, they could call a hotline. Most critically, he said he received 325 rounds from Theo Reed, which is important because ammo can be found at his shop at PDQ was found empty during the search warrant. Ms. Kenny also represented that hearing back 50 to 100 rounds through New Mexico and no experience where they went. The state also made repeated points at trial about guns being left unattended. Yet, as previously undisclosed interview, Kenny said the sheriff confused real and prop guns. Again, prop guns typically are real guns, so I'm not sure exactly what they mean. A prop is just anything you're using as a demonstrative aid. So most prop guns are real because it leads to better authenticity. Kenny also made conflicting statements on sabotage. This was favorable Giglio information the state suppressed and was material. The failure to produce is violation of the rules. Sounds like it. Suppression of the Hague report. The accident involving the firearm that led to the indictment occurred October 21, 2021. The state first charged Reed with involuntary manslaughter on January 31st, 2023, and commenced trial on February 28th, 2024. Ms. Gutierrez-Reed principal defense theory was that no one had committed a crime, and this was a tragic accident, and if there were any negligence, it was found on the part of producers, as found by OSHA. This defense would have been immediately bolstered by a legally unforeseeable intervening cause, such as a firearm malfunction that caused a death. This is perhaps the most important evidence of the case of an unforeseeable intervening cause. Indeed, post-trial, one of the jurors called undersigned counsel and said the jury was split and ultimately thought the tragedy was foreseeable and there was no intervening cause that caused the chain of causation. In short, the report is critical evidence. But what neither the court nor jury nor Miss Reed knew was that months after the trial, the state's two firearms experts, Hague and Hague, issued not just one report the state disclosed, but two subsequent reports. Specifically, the results of the initial examination of the firearm were published on a report dated of August 2023. The results of the second examination performed on August 2023 were published in two separate reports dated August 2023 and August 2023 respectively. The third Hague report found the firearm contained unexplained tool marks on working surfaces and sides of the Evans trigger sphere, and it was unlikely these tool marks are the result of damage incurred during the FBI's impact testing, and tool marks do not appear to be original manufacturing marks or use and abuse tool marks based on their irregular orientation. Put another way, the state's experts concluded that there were unexplained alterations to the firearm's trigger seal, a critical conclusion given the co-defendant had claimed that he never pulled the trigger. The state, however, did not produce the third report prior to the commencement of the trial. Instead, the state produced them only to Baldwin, only weeks after the jury convicted and courted sentence. Not great. It was only after May 31st, 2024, by which time Reed was already at a Western New Mexico women's prison in Grants for intake and classification, that Special Prosecutor Morrissey admitted to Baldwin's counsel the state failed to disclose the supplement for almost 9 months. You're walking without much help from McCain now? That's awesome, Tony. I'm glad to hear that you're recovering so nicely. I hope the surgery will produce all the wonderful results you were hoping for. You are awesome, Maud. You're an awesome Maud, Tony, and we love you. The timeline of the state's discovery disclosures in the case is important to understand for the purposes of the motion. In January 2024, Mr. Baldwin made an initial discovery demand. Between April 22nd and April 29th, Mr. Baldwin repeatedly raised concerns to the prosecution about missing materials. Then on April 29th, Baldwin apparently learned of the second report when Hague referred to it during a pretrial interview. And was then more than a month later that Baldwin's defense learned of the existence of the third report during a pretrial interview. Meanwhile, the state was actively prosecuting Reed. Her trial began on February 28th, and the jury delivered a verdict on March 6th, and the court imposed sentence on April 18th. And during the trial, her attorney examined Haig about the precise exculpatory issues raised by the report. Yeah. At the same time, Lucien Haig gave the sworn testimony. The state possessed a report stating the exact opposite, which would have been really helpful for the impeachment. Specifically, that the firearm contained unexplained tool marks on working surfaces inside of the trigger that are unlikely are the result of damage incurred during the impact testing and do not appear to be original marks. Although Haig's trial testimony directly contradicted his conclusion in the report, the state continued to withhold the report and its contents. That sounds pretty material. With the third report, Reed would have had sufficient evidentiary basis from which to argue the unexplained alterations on the firearm caused the fire with anyone pulling the trigger, an unforeseeable intervening cause that rendered her conduct not legally responsible. This would be a critical factor for the jury's decision, nor was she able to impeach Haig's testimony with prior inconsistent statements. Yeah. This week, the defense also became aware of another 900 or so pages of material related to state's witness Carpenter and Haig that was not disclosed. This material was disclosed to counsel for Baldwin shortly before his trial. It appears this material consists of email communications between the state and those witnesses that were not disclosed by Morrissey. Counsel are still reviewing these at the time of filing this motion and may supplement this exhibit in reply. It is too important for Ms. Reed to have her motion filed immediately, given the July 12th hearing and findings. As just one example, Exhibit E are numerous emails, approximately 36 pages, involving Carpenter and the state prosecutors. In one day, January 18, 2023, between the state prosecutors and Carpenter, relating to the drafting of Baldwin's probable cause statement. In that email, Carpenter says, in part, first off, excellent job, Robert, very compelling document and well written. I will redline if I find anything notable. In another towards the end, he appears to have emailed additional thoughts relating to Reed's probable cause statement. As the court may recall, Carpenter was the state's expert witness in the Reed trial as well. This email is one that counsel has located in a cursory search demonstrating the expert's bias towards the prosecution and the fact that he's involved in helping a draft a probable cause statement supporting charges. Well, that's pretty intermingled for a witness to be involved in drafting the probable cause statement. That's pretty, yeah. That's definitely a thing that you would want to know. In yet another, he states that Sarah Zachary knew nothing or next to nothing about firearms. He goes on to state that her hiring was for low budget reasons, and the only thing to mitigate it was to hire a more experienced armorer. But that didn't happen again, more likely for low budget reasons, blaming production. In another email on November 17th, Carpenter writes to producers that he's talked to one of 3 prop houses owners in the United States, and a very well-known prop master, and both of them, without hesitation, felt a majority of responsibility fell on the prop master. He goes on to believe Hannah is very accurate in stating the statements for production were jumping on her ass for not working hard on props, and they want more props done in the area to save money. He stated that Gabrielle Pickle was the one from producers who was stonewalling all the training and armor day requests. He references people believing Pickle and a member of production being responsible. He notes to blame production bringing the prop master and armor in late, not giving them prop trucks, and having locations working on the same truck as being completely wrong in the fault of production. So we're definitely getting some ideas of how these apparently late disclosures, late disclosed reports, late disclosed evidence, late disclosed emails, apparently 900 of them, 900 pages of them. You know, there's a lot here if you take the defense's characterization of it, which at this point I'm more inclined to do than the prosecution's characterization, because the prosecution, as you know, shown itself to be somewhat unreliable. And so I'm more inclined to take their word for the defense's word for it, because, you know, points vaguely in the direction of everything. So in the interest of time, I'm going to skip a couple pages here. Well, that's the end of the facts. But, so they talk about Brady. Evidence is mere material when there's any reasonable likelihood it could have affected the evidence of the jury. To prevail in the Brady claim, they need not show that she's more likely than not would have been acquitted had the new evidence been admitted. She must only show the evidence is sufficient to undermine confidence, which I think you're there. The state of New Mexico imposes some additional obligations. We're entitled to new trial or dismissal. I would really push for dismissal. I really push for dismissal because it's just not fair. It's just not fair. It's like, yes, we could go back to trial and now have all the disclosure, but it's not fair. So I don't know whether or not she'll get disclosure, but many of these factors go in her these stuff. Yeah. Morrissey testifies she didn't disclose the Hague report. Yeah. So there you go. Exactly. Excuse me. Then they talk a little bit about Brady, which means you have to disclose favorable evidence. There's no legitimate dispute. Given that it's stipulated, failed to disclose evidence that's both favorable and material. As the first factor, the report's favorable. It corroborates defense's theory that exculpates Reed's and might have changed the jury's mind. The jury accredited this theory. The jury would have acquitted Reed. But Reed was not able to pursue the theory because they buried the evidence. The fact that Reed asked the question and Hague perjured himself, or at least, if not perjured himself, at least there was evidence that contradicted him, which we weren't able to bring up. All right? Just because a witness said one thing one time and another thing another time doesn't necessarily mean either's a lie. They could be mistaken. There could be a lot of things, but you still have the ability to challenge it and be like, hey, didn't you say this one thing the one time and the other thing the other time? And, bring that to the jury's attention so they can consider it for reliability, for example. So there's that. So I'm not sure I would necessarily lean super hard on the perjury, but, it's fine for rhetorical posture. It's not strictly speaking necessary, so whatever the state's intention, there's no dispute that it failed to disclose the third Hague report, and that's all that matters. Whether it's intentional or not doesn't affect Brady. That's true. The state's failure to disclose until months after trial constitutes a violation of her due process and warrants a new trial. While the violation is sufficient to vacate her conviction, under relevant law, the rights under New Mexico are even more expansive. That also gives her the chance for a new trial. Okay. In the alternative, they should grant release pending appeal. That's fine. And then conclusion. Yeah, I mean, I'm on board with all that. And then they include some examples from the emails, which we already talked about in some detail. So, yeah. So, as a judge, I'd strongly be inclined to grant a hearing on this and hear these arguments and hear witnesses and testimony. And of course, I could take official notice of any testimony that was given in the prior proceeding. So, to bring that in and reconsider it in this new context. So, yeah. But I'd be strongly inclined to grant a hearing. And then if the defense is able to prove this, they get a new trial at the bare minimum. And I'd strongly consider dismissing outright because it's just not fundamentally fair. It's right, because the court can order the remedy that it feels is warranted. And with the effing around and finding out factor, and it's like in the interest of justice, like setting the whole thing aside would be something I'd be inclined to do. So I feel like the defense has made some good points. and I think a hearing is warranted by the trial court. So that's probably what I do. I'd have a hearing, and I'd be like, okay, we're going to have a hearing on this date. You can bring in witnesses, and we'll go from there. What's Giglio? It's just a follow-on case to Brady. Just a follow-on case to Brady that clarifies Brady and expands it, tells you a little bit more about what it means. Can the DA get out of this by not contesting the motion? Yeah. The DA could agree. The DA could agree to vacature. They could agree to dismissal. Sure. Thank you for the super chat. I thought Giglio was the case that said that Brady applied to police. But is it not Giglio? Is it something else? Let me do a quick search. What case is it that extends Brady to the police? Where is it, Giglio? Because I think Brady only initially applied to the pitches. See if I can find this. If it gets dismissed, it's with prejudice? Not necessarily, no. It probably, I'd strongly consider it, but I'm not sure it's required because of the timing, which doesn't necessarily sit well, but Giglio was 72. Pitches is California. I think there's a U.S. Supreme Court case. Alan Parker, thank you for the 20 gift memberships. It wasn't Brady itself, was it? Thank you very much, Del. Thank you very much, Sarah. So try to figure out. Yeah, Giglio just deals with. I think it looks like it just deals with materiality. Yeah, it's just the thing of, yeah. Every description of Giglio I've read is indistinguishable from Brady. Yeah, it's just a little clarifying. It's just a little extending case. Is it Bagley? Yeah. So Brady does not define what kind of evidence is material. That's where, like, says Bagley that comes in. Brady rules premise on due process. Or is Bagley just the one that makes them required to actually go actively look for it? Oh, Bagley deals with impeachment. Yeah, maybe Brady dealt with the police in the first instance. Rose has it posted. Yeah, I was under the impression, or I guess maybe it was a false memory. I was under the impression that there was a follow-on case to Brady that made it more explicit that it applies to the police as well. But maybe that was just a false memory. I guess Brady did apply to the police in the first instance, and then Giglio just clarified what materiality was. Okay, fair enough. Fair enough. So I just misunderstood something from the Supreme Court. Okay. All right. So, okay. Brady requires prosecutors to disclose any information in the government's possession. Bagley, not Brady, Bagley meant that the prosecution has a duty to disclose the information regardless of a request. So Brady said you have to give it on request. Bagley, a follow-on case, then said you have to give it even if they don't request. The most common outcome of Brady rule violation is overturning the conviction. But if they did so intentionally and knowingly, they can be subject to sanctions, which might include dismissal. All right. And then in Kyles v. Whitley, the Supreme Court clarified a little bit more. And then Giglio just clarifies a little bit more about materiality. Okay, cool. All right. I think I got it. Yeah. So Giglio extends the Brady rule to include evidence that could impeach credibility. Well, which I already thought was in Brady in the first place, but okay. Oh, but deals or arrangements made with witnesses. Okay. Fair enough. All right, cool. All right, good deal. All right, we've now clarified the state of the law, and I'm happier. So Brady applied to the police in the first place. So Brady always applied to the prosecution and police. Bagley said they have to give it to you actively, as opposed to merely requesting it. Kyles gave a 4-part test for when this should be given after trial, and Giglio said that it also includes deals and other incentives that might cause bias. Great. We now understand the case law better. Great. So we now understand the case law better, and my Supreme Court knowledge has increased. Fantastic. Great. What else can I answer for you before I sign off? So yeah, I think she's entitled to a new trial at the bare minimum, assuming this is true, and I'm inclined to believe her. I assume it's true, and if it is true, then I assume she should get a new trial, and because willfulness and intentionality has already been found, the sanction of the sanctions are could be dismissal with prejudice, which would be pretty hilarious. I am not at my best today. I'll tell you what, man. I'm not feeling great today. All right. Well, it looks like we've answered all the comments in chat. So that being the case, I'm going to go ahead and sign off and try to get a little bit more rest if I can. So it's been fun being here. My prediction is that the judge will hold a hearing on this. And assuming that the defense is able to do everything they're saying they're doing, we're looking at a new trial at a minimum and quite possibly dismissal with prejudice just because the judge is mad at everybody. So I think that that's where we're headed within the next couple weeks. So we'll see how it goes. All right, I'm going to sign off for now. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.